Well, hopefully the directive is if you're in trial, you show up.
I'm sure it is.
Okay. I don't think you have anything left here on Monday. It's two Ms. Olivier cases and it's Miss Charles who's got one.
We won't be up again until the February calendar.
Do you have Mr. Hill? Is that your case?
Mm-hmm.
Hope we can do that one.
So you sound excited about that case.
Oh, it's just the person's been in jail for a long time. The state's been ready. The guy switched lawyers. He's retaining lawyers, so it's not we had a staffing issue on the indigent side. It just that lawyer kept slowing things down. And based on my understanding of the case, I understand why it's slowing it down. All right, I think all systems are go. Ms. Rivers, good morning. Can you hear us?
Good morning. Yes, I can.
Excellent. Then why don't we, how would you like to start? Have you all spoken, or we want to do Mr. Greer first because we've got Mr. Shapiro here. Mr. Jordan needs to be here both for Mr. Holt. We'll do your cases first, to be clear. Is there one you guys want to do first? I'm neutral.
We'll take it because you're waiting on another person to come. So we'll just take Mr. Shapiro's case.
Okay. And as I understand it, so that's Mr. Greer. We'll bring Mr. Greer out. He's pleading to an accusation. Ms. Nelson shared with me that number. So I've got that and I'll get that in the record. She said she wasn't finding it in Odyssey quite yet. So it's that fresh off the presses. I'm not troubled by that as long as if the 23 SC 185848 is the magic number, that's what Ms. Rivers needs, and we'll all build off that.
And it's showing up in Odyssey now, Judge.
Good. Okay. Then let's bring Mr. Greer out, please. And Ms. Walker, you can be at the podium or you can be at the table. I don't know if your clients, I know Mr. Holt, I know he can be at the, I just don't remember if Mr. Greer, if it's easy for him to be at the podium. Great. If you'd prefer to be there, as long as people are talking into that microphone, Ms. Rivers will be able to hear it.
Okay, that's fine. Both of them are ambulatory.
Okay.
So we can do it how you like it. You can get the podium.
Yeah, there's just the sound is better for Ms. Rivers if folks are at the podium.
Mr. Greer. All right, let's get going. This is case 23 SC 185848, a new accusation, State versus Sam Greer. How you doing, Mr. Greer?
I'm doing good.
I'm Judge McBurney. I know we've met on a screen before. I don't know if we've met in person, but your case was assigned to me. And Ms. Walker tells me that you are prepared to enter a plea to this new accusation, which is a different charge, and we'll hear about it from Mr. Shapiro in a moment. But if you are ready to go forward, then Mr. Shapiro is going to put you under oath in just a moment. Once you're under oath, you'll need to answer all of his questions and mine truthfully and completely. Will you be able to do that?
Yes.
Great. The other important thing you need to do is let your lawyer or me know if you've got questions of your own. If someone says something that doesn't make sense or is going different from what your lawyer had told you, you need to say, wait a minute, I'm not following what's going on. And we'll pause. You and I can talk about it. You and Ms. Walker can talk about it. But I need you to let me know if there's something you're not following. Will you do that?
Yes, sir.
Great. Mr. Shapiro.
Mr. Greer, would you please raise your right hand? Do you swear or affirm that any statements or testimony you will give in this matter now before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you, sir. You can lower your hand. Would you begin by stating your true and correct legal name for the record?
Sam Greer, Jr.
And Mr. Greer, are you at this time taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you've not taken or been given today?
No, sir.
How old are you, Mr. Greer?
29.
And how far did you go in school?
I completed
Okay, completed high school, college,
military school.
military school. Are you able to read, write, and understand the English language, sir?
Yes, sir.
I'm sorry to interrupt, Mr. Greer. So military school, was that the equivalent of graduating from high school, or was that some school after you finished high school as well?
It's equivalent.
Okay, thank you.
Mr. Greer, is it your understanding that this case has been reaccused to charge you with a single count of felony family violence battery?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, sir.
And do you understand that if you were to plead not guilty, or if you were to remain silent and not say anything at all, then the state would be required to prove that charge against you at a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances that are related to this charge in the new accusation against you?
Yes, sir.
Would you like more time to discuss the case with your attorney?
No, sir.
And are you satisfied with your attorney's services?
Yes.
And counsel, are we waiving the formal reading of the accusation for purposes of the plea?
We are.
And are we waiving any and all defects with the accusation?
We are.
Thank you, ma'am. Mr. Greer, has your attorney advised you of the possible maximum sentence for the charge to which you are entering a guilty plea today?
Yes, sir.
Okay, so you're aware that you face a potential sentence between 1 and 5 years in confinement for this charge?
Yes, sir.
Is it your understanding that today you're entering what's called a negotiated guilty plea, which means that the state is going to recommend the following sentence to the court? For the single charge of felony family violence battery, the state is going to recommend a sentence of 5 years to serve 2 in custody, that time be commuted to the time you've already served, and that you serve the balance on probation, with the special conditions that you're to have no further violent contact with your family members, who I'll list for the court soon, and that you are to enter and successfully complete a family violence intervention program. Is that your understanding of the negotiated plea you're accepting today?
Yes, sir.
Okay. Do you understand that the court is not required to accept the state's recommendation?
Yes, sir.
And do you understand that the court does have the right to sentence you to the maximum possible sentence for this charge?
Yes, sir.
Mr. Greer, are you currently on probation or parole?
No, sir.
Do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, sir.
And do you understand that while on probation, you must follow all of the special conditions of your probation, including those that I've just described?
Yes, sir.
And do you understand that if you fail to follow the special conditions of your probation, then you may be subject to a revocation of that probation for the balance of your sentence?
Yes, sir.
Mr. Greer, do you understand that because you're pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, sir.
And do you understand that doing so could result in new criminal charges for which you would face a sentence between 1 and 5 years?
Yes, sir.
Do you understand that because you're pleading guilty to a felony, you also may not use a firearm in the commission of a crime in the future?
Yes, sir.
Do you understand that if you were to use a firearm in the commission of a crime in the future, then you would face a consecutive sentence, which means a sentence in addition to whatever the underlying felony is for using that firearm?
Yes, sir.
Mr. Greer, do you understand that by entering a guilty plea today, you're waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, sir.
Is it your decision to waive those rights, which means not to use them, and to enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to enter this guilty plea because you are in fact guilty?
Yes, sir.
All right, Mr. Greer, in case number 23 SC 185848, how do you plead to the charge of felony family violence battery?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness of your plea or any other constitutional aspect, you would have to do so by filing what's called a habeas corpus petition?
Yes, sir.
And do you understand that because this is a felony charge, you have only 4 years from today to file a habeas corpus petition if you wish to challenge the voluntariness of your plea?
Yes, sir.
All right, thank you very much, Mr. Greer. Your Honor, as for the factual basis for this charge, on November 8th of 2020, investigators with the Atlanta Police Department responded to 501 Aberdeen Drive in Fulton County in response to reports of child abuse. They met with a defects worker who was conducting a wellness check after receiving information from a family member that there was suspected abuse going on in the home. Grady EMS responded to the scene and evaluated several children who were residing in the home, including the defendant's 11-year-old stepchild, whose initials are OP. APD photographed the injuries to the child, which included a small scab on his left temple. The child did not require hospitalization, but was treated by EMS on the scene. The children and the mother all disclosed that the abuse was perpetrated by the defendant, Mr. Greer, who is the mother's husband and the 11-year-old victim's stepfather. On December 9th of 2020, the victim OP was taken to the Georgia Center for Child Advocacy, where he underwent a forensic interview. And during that forensic interview, he disclosed that his stepfather, the defendant, had struck him across the head with a stick, and that had caused the injury to his left temple. Judge, in investigating this matter, the case was originally indicted, as the court knows, in case number 22 SC 181498 as a single count of cruelty to children in the first degree. The basis for that charge being the child's outcry that Mr. Greer had struck him in the head with a stick. In investigating this case, the state subpoenaed the DFACS records for the family, which were extensive. There are conflicting reports by each of the children as to who was perpetrating the abuse in the home. However, what seems to be consistent is that there was ongoing abuse by both the mother and the defendant, Mr. Greer. There is also a February 2021 entry in which the DFACS case manager conducted an interview with the 11-year-old victim in this case. At that time, he recanted what had been his prior statement about what had caused the injury.
The stick.
What he said in attempting to, as the caseworker describes it, in attempting to clarify, is that he was being spanked with what he described as a switch that he had moved, and that the switch had struck him above his left eye. He stated that the defendant had apologized. The child was asked about, does he know how to differentiate between a stick and a switch? And he said he could. The state also reached out to the victim and the victim's mother. And in discussions with them, the victim's mother has denied that this incident ever happened. And so, Judge, while the state believes that the recantation could be potentially explained by the cycle of domestic violence that seems pretty prevalent in this household, ultimately, the state must make a determination on whether it can prove the charge as indicted to a jury.
I'm sorry, keep going.
Given the recantation and given the differing accounts of what actually transpired between this victim and the other children, the state questions its ability to prove this particular charge. However, again, what seems apparent is that there is ongoing domestic violence in the home. All of the children are consistent in their description of that.
So that leads to my question, which is Mr. Greer already has a family violence battery. It was a state court case. Who was the victim in that?
That's correct, Judge. And what the state has marked as its one exhibit, State's Exhibit 1, is a copy of that conviction. It is that conviction that elevates this to a felony family violence battery. And excuse me, Judge. The victim in that case was the defendant's wife, who is this 11-year-old victim's mother. Her name is Jashari Greer. The state, again, has spoken with Ms. Greer. She no longer resides in the state. All of the children are still living with her, living outside of the state. So the state has discussed the resolution with the mother of the victim. They are in agreement with this proposed resolution that will place Mr. Greer on probation for the remainder of his sentence, which is a little over 3 years now. And that he will undergo and complete the family violence intervention program and will not have any further violent contact with Miss Greer or with any of the children.
Sure. And you said she's moved out of state.
She has.
In talking with her, is it her expectation that she and Mr. Greer will be reunited? Because that's a little complicated with probation. That reunion could not occur right away because Mr. Greer would need to get his probation transferred to another state.
Yes, Judge. And it's unclear in my discussions with her. It seems that at the very least, she intends that Mr. Greer will continue to have a presence in the children's life. And yes, that will complicate the probation, which if he intends to be visiting the mother and the children out of state, will have to be transferred.
Okay. Got it. Anything else?
Judge, as for Mr. Greer's criminal history, the state will just note for the record that he has 4 arrest cycles and a single conviction, but that was a First Offender Act conviction. So he stands before you without any felony convictions today.
So I know about the misdemeanor family violence battery. What was the first offender disposition?
The first offender disposition was for a felony burglary case out of Fulton County. He entered a plea in that case on October 4th of 2011 under
so
the
that's
First Offender
all right.
Act.
That's a long time ago.
Long time ago, Judge.
All right. Thank you. Good morning, Ms. Jackson. How are you doing?
Good morning, Your Honor. How are you?
I'm well. Do you have anything additional or that is different from what Mr. Shapiro said about Mr. Greer's criminal history?
No, Your Honor.
Okay. Thank you. Ms. Walker, tell me about Mr. Greer.
I've spoken to Mr. Greer, and there were additional facts and allegations that were made in this case that prompted us to accept this family violence battery. And he is, as you've learned, a high school graduate, and he is otherwise has not had any substantial trouble in Fulton County or in the state of Georgia or anyplace else. And he is here standing present before you to accept responsibilities for his charges.
Okay. Mr. Greer, do you know where Ms. Greer has moved to, or is that unknown to you? I don't know. I'm wondering if she stays in touch with you.
No, sir.
Okay. All right. Were you working before you got arrested in this case?
Yes, sir.
What kind of work?
Construction.
All right. Were you working for a company, or was the kind of construction where you sort of pick up jobs as you could pick them up?
A company.
What was the company?
Mackenzie Young.
Okay. Any sense of whether you can go back to that when you get out?
Yes, sir.
Okay. How long have you been in custody?
21 months.
Just what, 21 months? Okay. All right. How many kids do you have with Ms. Greer?
6.
And does that include Orlando? Or I know he's a stepchild. I'm just wondering, do you include him in that number of 6, or he is outside that number of 6?
Outside.
How many kids does Ms. Greer have total? 8? Okay. But 6 of them are with you.
Yes, sir.
Okay. Did you know she had moved out of state?
Yes, sir.
Okay. You just don't know where she is.
Yes.
I'm inclined to accept this resolution. I'm going to structure it a little bit differently, not in a way that is going to make things worse for you. But I want to make sure you understand that your probation will be in Georgia. And if you learn where Ms. Greer is and she wants you to join her and you want to join her, you can only after you work with probation to get your supervision transferred. So I'm going to make it up. Let's say that she's in Kentucky and you decide, I want to be there with the kids. I can do construction work in Kentucky. I can help take care of the family. I've had my family violence intervention program, so I've got some good tools to work with stress, short of getting physical with people. For you to move to Kentucky, probation would need to transfer your case to Kentucky. And it just doesn't happen overnight. It's doable, but it takes a little while. And so I want you to understand that you wouldn't simply be able to call probation and say, hey, I'm on my way to Louisville, because that's where my family is. See you guys later. You'd have to work with them and wait till supervision was transferred. Does that make sense?
Yes, sir.
You willing to do that?
Yes, sir.
So when you get out, and you'll get out in the next few days, do you have a place to stay?
Yes, sir.
And with whom will you be staying?
My parents.
Okay, good. And they know you'll be getting out soon?
Yes, sir.
Okay, and they'll let you stay with them.
Yes, sir.
Is that in the Atlanta area?
No, sir.
Is it in Georgia?
Yes, sir.
Okay, where do your folks live?
Decatur.
Oh, okay. That's Atlanta area. Okay, Decatur. Got it. It's not Atlanta, it's Decatur, but it's metro. You're not going down to Albany.
No, sir.
Okay, all right. Do you have any questions about anything we've been talking about?
No, sir.
All right. You understand the family violence intervention program, it's not just one class, it's a series of classes that you'll need to do?
Yes, sir.
Okay. All right. Well, Mr. Greer, I find there's a factual basis for your plea to family violence battery. I also find that your plea is knowing and voluntary. Voluntary means that you've decided, after consulting with Ms. Walker, that it's in your best interest to take this plea. Is that correct?
Yes, sir.
And a knowing plea just means you've understood everything. You're clearly a smart person and you have told me, I understand it. So I'll take you at your word. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a small violation, we call them technical violations. Maybe you miss a meeting, you and probation work through that. I don't have to get involved. But if it's serious, you get arrested, you leave the state without authorization, that kind of stuff, that comes back to me and we'll need to work through the consequences. But of course, if you're just keeping your head down and working in construction and taking care of your folks, you don't need to worry about probation and they don't need to worry about you. Do you, Mr. Greer, authorize my staff to sign this accusation electronically indicating your guilty plea?
Yes, sir.
And Ms. Walker, may we sign for you?
Yes, Your Honor.
And Mr. Shapiro?
Yes, please, Judge.
Mr. Shapiro, are you moving to null pros, dismiss 22 SC 181498?
The state is moving to null pros that case, Judge.
We'll take care of that. Do you have any kids, Mr. Greer, outside of your relationship with Mrs. Greer?
No, sir.
All right. Well, Mr. Greer, I am going to sentence, you said 21 months?
Yes, sir.
Okay. So I'm going to sentence you to 5 years to serve. I'll make sure I do the math right. 18 months. It's 5 years to serve 18 months. You're going to get credit for all the time you serve. So you have served 18 months. It means you'll be released, if not today, because it's a Friday, probably this weekend. If it gets into next week and you're still in jail, you need to call Ms. Walker. She will call me. I'll make sure you get out. But next few days, you should be out. So you're going to be on probation for 3.5 years. The number one condition of your special condition will be no violent contact with any of your immediate family members. That doesn't mean you need to stay away from Ms. Greer and your kids. It just means that when you're with them, if it results in anything like this, it's really a crime, but it's also going to be a violation of your probation. Second special condition of your probation is that you complete a family violence intervention program. Okay? I'm going to require that you get that done in the first 6 months of your probation. All right? And I will waive your probation supervision fees for the first 2 months while you get back on your feet, get a job, and this family violence intervention program is not free. So you won't need to pay the supervision fees until month 3. Mr. Shapiro, anything else in Mr. Greer's case?
Nothing further from the state, Judge.
Ms. Walker?
Nothing from the defense, Your Honor.
All right. Ms. Tucson, who is seated in the jury box, is with probation. She may have a couple questions for you, probably about your folks' address, because she needs to tell you where to report. Are we able to give him a piece of paper with reporting instructions? Excellent. You're going to get a piece of paper telling you where to report. If you're living in Decatur, that means you're living in DeKalb, and it's just a different probation office than the one I'm used to, which is about 2 blocks away. As long as you're living in Georgia, that's fine. We just need to know where it's going to be, so we have you showing up, and they'll be actually looking for you. The worst decision to make, other than going to find Ms. Greer without getting permission, would be to miss that initial probation appointment, because they just spit out a warrant. And then I see you again dressed like that. Any questions about anything?
No, sir.
All right. Mr. Greer, you've been in jail for a long time. I hope that has helped clear your head about things and that you are ready to be out and be done with that.
Yes, sir.
Good. Okay. Ms. Tucson, are you going to see Mr. Greer back there, or do you want him to stay right here? Okay, great. All right. Thank you, everyone.
Judge, if you need the state to submit a proposed order, null pros, or will?
No, it'll just be stamped and signed.
Okay.
So that is taken care of. Thank you, Mr. Shapiro.
Thank you, Judge, and that's all my business this morning. After this excuse.
It is, and you may.
Thank you. Yes.
How you doing?
Hey, Mr. Adams. No worries. As you saw, we're going to take one more plea. We got one other person in custody, and then we'll do Mr. Avery. Okay? Sure.
So it is I want to do 12 to serve 7. I didn't even put that.
This is what, yes.
I copied you on that. Yes.
I mean, straggler.
Yes. Yes, ma'am.
So he only did 6. So I just do 12 to 37.
Okay.
And we'll dismiss the, he was found not guilty at the trial with the burden. So it's counts 4 through 6.
Okay. All right, thank you.
Mhm.
Congratulations on the wedding.
I appreciate
I saw the bride,
Yeah,
but I didn't get to see you.
she just left, so she's doing private work
No, criminal?
now. Yes.
Can you tell the phone?
I definitely will.
Mr. Holt,
Yes, sir.
how are you?
Good, sir.
Told you we'd get you a lawyer.
Thank you, sir.
Don't
You
thank
did.
me, thank Ms. Walker.
Ms. Walker.
She is a busy woman. She works with Mr. Johnson. But when I explained that we had a situation, Mr. Jordan said, we can work this out. And I explained to Ms. Walker, Mr. Holt's about to represent himself. Never a good idea. She said, if it's a quick touch, I can come in here and help. So my understanding is that you're prepared to enter a plea pursuant to some terms that'll be shared with me in just a moment that will finally bring closure to your case from 2016 after a trial, a conviction, a reversal, and all of the winding road you've been on. Is that ready? Is that correct?
Yes, sir.
Okay. Well, then in just a moment, Mr. Jordan will put you under oath. Once you're under oath, you'll need to answer his questions and mine truthfully and completely. Please let Ms. Walker or me know if you've got any questions of your own while we're going through this. There shouldn't be any surprises, but sometimes someone says something a little differently than what you talked about with your lawyer, and you need to tell us to pause if it's not going the way you thought it was going. Okay?
Yes, sir.
Great. Jordan.
Your Honor, before we begin, this will be, count 1 will be a reduction from armed robbery to robbery, OCGA 16-8.
Hold on one sec. I need to pull, Ms. Nelson sent me the indictment and I need to pull it up because the charges aren't on the calendar. There we go. All right. So I got all 6 counts in front of me. So count 1, you're reducing to robbery.
Yes, Your Honor.
Okay.
State will be dismissing counts 4 through 6.
Okay. So it's a plea to robbery, aggravated assault, and aggravated battery.
Yes, Your Honor.
Got it.
And the state is ready to proceed, Your Honor.
Let's do it.
Mr. Holt, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Zacchaeus Holt.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
My seizure medicine, but I get it at nighttime.
Okay, and that, do you know what kind of?
It's
medicine it
Dilantin.
is? What?
Dilantin.
Dilantin?
Yes, sir.
And do you know the normal dosage that you normally take?
I'm not sure. I just know I get it in the evening.
Did you get it last night?
Yes, sir.
You got the medicine last night.
Yes, sir.
Great. And when you take it, does it have any effect on your ability to understand what's going on? Does it make you woozy or dizzy?
No, sir.
Okay. And it sounds like the next day it doesn't have any impact other than it helps you with seizures.
It doesn't really have no physical impact at all.
Good.
I don't feel it.
Okay. So it's not, you understand where you are and what's going on. But hopefully you won't have a seizure because you've been taking the medicine.
Yes, sir.
Excellent.
Thank you, Judge. How old are you, Mr. Holt, and how far have you gone to school?
I'm 27 years old. I completed my GED in prison.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses, even though you're only pleading to 2 of these offenses that were originally on the indictment? Armed robbery, aggravated battery, aggravated assault, burglary in the first degree, possessing a firearm during commission of a felony, and possession of firearm by a first offender probationer.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Joy Walker, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Walker, do you waive formal reading of the indictment?
I do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Holt's name?
I do. One moment.
Your Honor, the state is unaware, my apologies, Mr. Holt, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Walker, do you know of any outstanding warrants related to these charges?
I do not.
There better not be the whole charge, other than the bench warrant, which is why you're back in custody.
Mr. Holt, has your attorney advised to you the minimum and maximum sentence for each charge that you're pleading to?
Yes, sir.
And just for the record, Your Honor, for count one, which would be robbery, the minimum is 1 year and the maximum is 20 years. For aggravated battery and aggravated assault, the minimum is also 1 year and the maximum is 20 years. And as previously stated, the state is moving to dismiss the remaining counts. Mr. Holt, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? And Your Honor, I apologize. I tried to do the math as far as how long Mr. Holt had been in custody. From what you just stated, I thought that he had been in continuous custody since the trial ended, but it sounds like he may have had a gap in there.
And he can tell him, he may not know by day, but if we're close enough. But Mr. Holt was in prison for a while. He was found guilty, gets reversed. Then he got a bond, was on bond for a while, and then missed a court date. We don't need to get into why he missed a court date now. We moved past that. But because of the missed court date, went back into custody and has then been in jail for a while longer. But there was a window of freedom that he enjoyed after the reversal from the Court of Appeals.
And you are approximately right with regards to the 6 years.
Okay.
So,
Okay.
yeah, so
Absolutely.
that approximation, but I've told Mr. Holt that you're going to give him credit for all the time he's already served, and then that's all.
Thank you so much.
I see the docket in the system already, so is it just being redone?
So Mr. Holt went to trial and was found guilty and was sentenced. So he'd be in the system, but that conviction was reversed. There was an appeal and it was reversed. And so he is again not guilty. He's about to be guilty because he's going to plead, but all those counts are open and he has no sentence. So if he is in your system with a sentence, that's an old sentence that was vacated by the Court of Appeals when they reversed his conviction. So we're starting from scratch.
I'll email the manager who does these, so that way they can.
Good. Yeah, we wouldn't want there to be confusion about that. But there'll be a brand new disposition that goes in, new final disposition, and that will be what guides any supervision going forward.
Under the same document.
Same docket number. Yeah,
Thank you.
you're welcome.
Well, Your Honor, with that understanding and from Attorney Walker, the state's recommendation was previously 12 to serve 7, commuted to time served, with the balance being probated. Your Honor, as I will detail later in the facts of the case, Mr. Kevin Watts is now deceased. He did pass away in July of 2022. I have no reason to believe that it's related to this particular incident. So the state's only condition is that he not return to the incident location for probation. I believe that the aggravated assault would merge into the aggravated battery. So the state's recommendation is 12 to serve, commuted to time served, to run concurrent with the robbery count, Your Honor. And I believe my counts may be out of order. I had ag battery as count 2.
Yeah, it's count 3. We'll talk about it. I don't think the aggravated assault merges because it is charges both choking and shooting. and the ag battery is just based on the shooting, it's not going to change the sentence. But my initial reaction was, oh, we'll probably have to merge the two. But I need to hear your factual basis. But if there is any factual basis for the choking, that is not any element of the aggravated battery. And because of that separate element, I don't think they merge. But again, it's not going to change the sentence.
Absolutely understood, Your Honor. Mr. Holt, was that the negotiated recommendation that was communicated to you?
It was 10 to serve.
10 to serve. And
Right.
I originally, Your Honor, I did have 10 to serve 3 because I added up the amount of time that I saw on his jail screen, which was about 904 days, but not with the understanding that he had been in prison for quite some time before the case was successfully appealed.
So it sounds like your focus was making sure there was a longer period of probation, because 10 serve 7 would be 3 years probation. 12 serve 7 would be 5. 10 serve 3 would be 7 years probation. So I don't want to undo the negotiations. I'm probably going to impose a sentence that involves 5 years probation. We may have a behavioral incentive date. If everything's going well, he can come off it. But you can propose the structure you want. I'm probably looking at a 5-year period of probation with a behavioral incentive date.
Absolutely understood, Your Honor. My apologies for the confusion on the amount of years in the original recommendation. Now, with that understanding, Mr. Holt, do you understand that the court does not have to accept the recommendation that the state has just given?
Yes, sir.
Do you understand that the court can send it to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental units or the special condition of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, and including any mental health defenses, by answering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Holt, how do you plead to the charges of robbery, aggravated assault, and aggravated battery in indictment number 16 SC 140799?
Guilty.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since these are all felony charges which you are pleading to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Walker, did you advise to Mr. Holtz his deadlines for filing a direct appeal?
4 years? Yes, sir.
Thank you. And Judge, for a factual basis on this case, on October 18th of 2015, an officer was dispatched to 1870 Campbellton Road. Upon arrival, the officer met with the victim, Mr. Kevin Watts. The victim, Mr. Watts, was laying in his bedroom with blood surrounding him. He stated that he had just been shot by his roommate, whom he knew as Judo. Earlier that day, the victim and the defendant were in an apartment with an unknown male.
Judo, like the martial art?
Judo, yes, Your Honor. The defendant and the victim were in the apartment with an unknown male. Both of them knew that he had a large sum of cash somehow.
That Mr. Watts had a large sum of cash, or the unknown male did?
That Mr. Watts had
Okay.
a large sum of cash. The unknown male and Judo then left the apartment around 7:30 on that particular day. Judo then returned to the home alone, knocking on the door. The victim then saw Judo with a black handgun pointed at him, in which he told him to give him all of his money. The victim refused. A struggle then ensued, and Judo did fire the gun twice and hit Mr. Watts in the leg. The victim stated that the defendant then began to drag him around the apartment while choking him before he stopped and took $560 out of his wallet. Officers were able to lift a fingerprint off of a soda can that was in the apartment. The fingerprint did come back to the defendant, Mr. Holt. That led to his photo being placed in a lineup in which Mr. Watts was able to identify the defendant as the individual who shot him. And
As Judo?
As Judo, that's correct. And Your Honor, for the procedural history, which it sounds like you're well aware of, the defendant was found guilty after trial on September 29th of 2016. The case was then appealed and overturned on November 18th of 2019, which from my reading, Your Honor, it looked like due to improper character evidence being admitted. The victim, Kevin Watts, as I stated before, is deceased as of July of 2022. The state felt comfortable moving forward with this plea instead of a straight up no pros because Mr. Watts did testify at trial, so his testimony would be on record if the state did intend on trying the case again. But we believe with the amount of time that Mr. Holt has spent in custody, that this was a fair and reasonable negotiation, Your Honor. So we would just ask that the court accept this negotiated plea.
Okay, thank you. Ms. Jackson, what do you have for criminal history for Mr. Holt?
The defendant has 8 cycles. The defendant's last arrest was April the 11th, 2022 in Maury County, Georgia, for possession of marijuana with the intent to distribute and crossing state or county guard lines. Those charges were dismissed June the 2nd, 2022. In addition to that, the defendant appeared to have an outstanding hold out of Jonesboro, Georgia, for a failure to appear. The underlying charge was not listed. The date on that warrant was June the 29th, 2022. The defendant did receive first offender treatment in 2015 for robbery. That case was sealed August 16th, 2022. The defendant does have misdemeanor sentence and a conviction. The defendant received in 2013, the defendant received a no low contendere sentence in Clayton County for simple battery, family violence. And there was one in 2013 out of DeKalb County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you for that. The first offender robbery, what jurisdiction was that in? You've got Fulton? Okay.
Would you like to copy?
Yes, please.
15 SC 138 917.
Okay, great. All right. Thank you, Ms. Jackson. Thank you, Ms. Tucson. So Mr. Holt's not on probation through that. It sounds like that case is closed out. Okay. Ms. Walker,
Excuse me, Your Honor.
if you're okay.
My sinuses are draining. Hold on one moment.
Well, let me ask Mr. Holt some questions while you're doing that. Mr. Holt, when you get out, do you have a place to live?
Yes, sir.
And where will that be?
My fiance,
Is that back in
Fulton County,
Fulton County, but was it Fairburn? I'm trying to remember where you lived.
McDaniel Street.
Okay. And that's where you were living throughout the time we've been knowing each other? Or is this a
This is a new address.
new set? Is it the same relationship or
Yes, ma'am.
just a different address?
It's a different address, but it's the same relationship.
Okay. All right. Is that an apartment or a house?
A house.
Okay. And who else will be there besides you and your fiance?
It's me, her sister, and my son.
Okay. How old is your son?
He's 4 now.
4. And is your fiance the mother of the son or she's helping take care of the son?
Mother.
All right. Ms. Walker, you back?
I'm back.
All right.
You'd be happy to know that I went to the ENT yesterday. They gave me good medication.
Good. I want you to be well and not be
No.
COVID infected and
No,
getting
no,
us
this
sick.
is just
Sinuses.
seasonal.
Okay.
Yeah. All right. So as you're well aware, Your Honor, Mr. Holt has gone through quite a bit to get to this resolution, and we ask that you accept the recommendation of the state with your modifications with the 5 years. I did tell him about the behavioral incentive date, and we ask that you accept the recommendation of the state.
Okay. Mr. Holt, it has been a long and winding road. We're not going to revisit you and Mr. Watts. It's tragic that he's dead. I do hope that his early death was not precipitated by the injuries he received when he got shot. I don't know. And you're not saying that that's the case, Mr. Jordan. I knew he wasn't well because Mr. Jordan's predecessor was looking to resolve the case. I think it was 2 people before you. I think it was Ms. Charles was trying to work the case out and had some urgency behind it because Mr. Watts was not well. And she wanted to get closure on the case while he was still alive so that he would know what happened to the case. And through no fault of yours, you cycled through a few lawyers, and it was hard for Ms. Charles and then Mr. Hand to link up with a lawyer who could say, well, let me sit down with Mr. Holt. It's kind of complicated because it could be a trial again. But here we are. We've reached a point where I think there is a way to close this out. I do find there's a factual basis for your plea. I can't second guess what the Court of Appeals did, but there's a fingerprint and a photo lineup, and that's judo, and there you go. So I do find there's a factual basis for the plea. I also find that your plea is knowing and voluntary. Voluntary means that you're going forward with this plea of your own free will. You've had a chance to talk about it with a lawyer, think about it, and this is how you want to move forward. Is that correct?
Yes, sir.
And a knowing plea is simply one where you've understood everything we talked about. Any questions about anything we've been discussing?
No, sir. I just want to let it be known that I've grown a lot and matured since 2015.
I bet you have.
I've learned a lot, grown a lot, and matured a lot. I'm a whole different person than I was. That's all.
So that would have been, we've been 19 years old back. I mean, you're still a kid. Legally, you're an adult, but you're still a kid back then. And how old was Mr. Watt? Was he an older gentleman or he just died real young?
Your Honor, I believe that he was considerably older than Mr. Holt. I think he was only in his 60s, I want to say, when he.
Okay, but he's still, I mean, that's 20 years older than Mr. Holt. They weren't peers.
Correct, Your Honor. And it did seem like it was, I read some of the transcript, and it sounds like Mr. Watts let Mr. Holt live with him until he could find another place. And
Okay.
that's how they became roommates, I believe, according to the testimony in the case.
I didn't mean to interrupt you, though. Tell me why you think you're in a better place now. I mean, you're not in a better place, you're in jail, but as a mature man, et cetera.
When I was 19, I had never had a job. I had never worked a job. So since being out of prison, I got my GD.
You got a kid.
I have a kid. I have more responsibilities, and I just look at life a totally different way than I did. And I don't take my freedom for granted. And if you've been watching the news, Rice Creek is not necessarily la la land. People are dying in there. So that's not a place that I want to be, and that's not I know now not to do nothing or be around anybody that would lead me to a place like that. And I know now to make better decisions.
You're saying all the right words, and in a few days, you'll be able to see if you can walk like you're talking. But I wish you the best on that. You do have a devoted, significant other. She comes to court all the time. Don't let her down.
Yes, sir.
I'm sentencing you under the Probation Options Management Act, which means, Mr. Holt, that while you're on probation, which you will be for a few years, if you have a technical violation, something small, you and probation can work through that. You don't need to come back in here. But if you get arrested again, anything serious, that comes back to me. And that will likely be evidence to me that talk is cheap, but you haven't made those changes that you just described. I think you have, because you actually, while you were out for a while, things were going well. And so hopefully you can return to that. Do you, Mr. Holt, authorize my staff to sign the indictment in your case indicating your guilty plea?
Yes, sir.
And Ms. Walker, can we sign for you?
Yes, sir.
And Mr. Jordan?
Yes, sir.
All right. A little housekeeping. You were found not guilty at trial on the burglary count. So that does not need to be null prost. The jury took care of burglary. That's count 4. The state null prost count 5 before the trial last time. So you don't need to null prost it again. Only count 6, which is possession of a firearm during commission of a felony, will be null prost now. You're not proceeding with that. 4 not guilty, 5 already null prost, 6 is being null prost now. The trial judge, Judge Downs, believed that the aggravated assault did merge with the aggravated battery. I don't, because of that choking element to it. It's not going to change the sentence, but this disposition will just look a little bit different. They won't merge. So, Mr. Holt, how many full years have you spent in custody if you add it all up? So you were in jail for a long time, and then more recently you've been in.
Almost 3 months away from 6 years.
Okay. All right. So I'm going to sentence you, Mr. Holt, and you'll get credit for all the time you've served, way back when and more recently, to 10 years to serve 5 years on all 3 counts. They'll run concurrently with each other. 5 years in custody, credit for time served. You've served more than 5 years. So you ought to get out in the next couple of days. If you wake up in Rice Street on Monday, call Ms. Walker, and then she'll let me know, and I'll make sure you get out. But you should be out before then. 10 years to serve 5 years. I need the incident location, because you know what? I don't need the incident location because Mr. Watts can't live there anymore. So I'm not going to put a stay away. It's a waste of a condition. I will set what did you have a question for me, or you're good? Okay. I'm going to set what's called a behavioral incentive date, and that will be January 27th, 2025, 3 years from today. If you've done fine on probation, have not been a headache for them, you're working, doing what you need to do, then probation will be reviewing your file and closing it out. So I'm setting that behavioral incentive date, again, January 27th, 2025. Before then, probation may approach me about making your probation non-reporting if you're doing well. So there's no reason you shouldn't try to make it happen before then. Given how serious these charges were and are, I'm all right with it being 3 years out. Worst case scenario, if you're a headache for probation, it's 5 years. You'll just do all 5 years of that. You were working before you went into custody. Are you going to be able to work right away when you get out, or is it going to take a minute to get back on your feet?
Probably right away.
What are you going to do?
Mechanic shop.
And you think you could go back there next week?
Yeah, I work for my brother.
Oh, well, he better let you back next week. All right, then that's how we're going to do it. Mr. Jordan, anything else in Mr. Holt's case?
Nothing further from the state.
Ms. Walker, anything else?
Nothing further from the defense, Your Honor.
Mr. Holt, any questions?
No, sir.
Okay. Thank you for being here again. You didn't think it would ever happen, huh? It happened. Have a good weekend.
All right, let me know. Let her know.
All right.
Thank you.
Thank you. I know you're done, but there had 3 people I wanted to talk to before we're done here this morning. You were one of them. So I want to just talk to you about a scenario and let me know how your office would process it. Mr. Johnson represents He's now probably the fourth conflict defender for a couple defendants who have been in custody for more than 1,000 days.
Okay.
They are trial ready. The state has been ready. And Mr. Johnson has said, I'll try it if I'm available. He's not. And the proposal I had, I just don't know politically how it would work, is that we get one or both of those cases out of your shop and to our C3 program.
Oh, no, we don't have any problems with that. He's not on individual contracts, individual cases.
He does have these are not them. I did learn, and it surprised me. He's got a couple clients in my docket where they've paid him. And so he's stuck with those and they're stuck with him, or they can hire someone else.
Right.
But these two people that I've got in mind, one is a case with whatever Miss Charles's unit is. It's a rape case. You know, there's a murder, so it's actually somehow gang related. There's only one defendant. It's a female. So I'm always surprised, but the gang unit has that. And I've talked with those.
I'm only seated, Your Honor. It's just, I need to take some notes.
It doesn't, no, you should feel free. I'm seated, you can be seated. But what I didn't want to do is have either Mr. Johnson, and I wasn't so worried about him, I think he'd be fine, but in particular, your office, like, wait a minute, you've just assigned a lawyer to a case that we ought to be staffing. But in my interactions with Ms. Glazier, the sense I got is folks will take all the help they can get. And I only picked these two because of that number 1,000. It's just such a big number. The other approach I had was to, on bended knee, get in front of you saying, could you get someone to try these cases? And your answer would be, sure, when I can.
Yeah,
And I just know how stretched people were. We had Ms. Hemingway in here on something. It's like, I can't do that. I'm not even supposed to be in this courtroom. But I didn't want to cause a stir. I'll send you an email with the information.
You won't cause a stir because Mr., unlike other attorneys that are paid per case,
Mhm.
he is not.
Okay.
He's a contracted, that monitors a courtroom. So there are two that are on staff like that. If you want to, you send me if you send me the indictment numbers, I'll close it to the C3 program for together.
Excellent. Okay, I'll do that. I'll do that today. The names, and one guy has 3 cases, and so we'll close all 3. The state's been real clear. We'll go 2 rapes. One of them they're ready to go forward on, and then the
Close all 3 to the C3.
yeah, and then the female has 2, but one is just a re-indictment. This gang unit won't stop, and so even though it's like 4 years old, like, hey, we re-indicted. Okay, it's still a murder, and there's not new discovery or anything like that. But I just, if there's a way to roll Mr. Johnson off those, then we can get great.
Without hesitation, Your Honor.
Okay, great. Then you're done.
Okay, thank you.
Thank you so much. If we come across other cases, Ms. Walker, like Mr. Holt or Mr. Greer, where it's hey, let me have 20 minutes with a client, we can probably make it happen. Can I reach out to you if they're Mr. Johnson's cases?
Of course.
Okay.
If there are any cases, as long as it's conflict in his office.
Yeah.
Any case.
Got it.
Let me know.
I will.
Mhm.
Thank you so much for your support.
Thank you.
All right, let's get Mr. Avery up here if you guys are ready. Oh, I'm sorry. Oh, she's back there. No, keep coming up. I forgot to let Miss Toussaint went back there. All right, we've got everyone we need on the Zoom. Mr. Avery, Mr. Adams tells me you're prepared to enter a plea in your case. Is that correct?
Yes, sir.
All right. You just sat through 2 of them, so you know how it's going to work. Mr. Jordan will put you under oath. Once you're under oath, answer his questions and mine truthfully. And if there's something that is said that doesn't make sense to you or is different from what you and Mr. Adams have been talking about, call timeout, talk with him, let me know, and we'll work through it. Will you do that?
Yes, sir.
Excellent. All right, Mr. Adams, are you ready to go?
We are, Young.
All right, Mr. Jordan, this is case 21 SC 179115. It's position 17 on the trial calendar. It's actually position 3 or 4 for Monday's calendar, so it had moved up. But it sounds like we're working it out
Yes.
when you're ready.
And Your Honor, just for the court's clarification, Mr. Avery will only be entering a plea to count 5. The state will be dismissing counts 1 through 4.
And is count 5 possession of a firearm by a convicted felon?
Yes. Your Honor.
Okay, got it.
Mr. Avery, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Here, LaShannon Avery.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
Sir.
How old are you and how far have you gone in school?
45 and I have my GED.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
You understand that you've been charged with the following offenses, even though you're only entering the plea to count 5.
Yes, sir.
Counts 1 through 3 being aggravated assault, and count 4 being possession of a firearm during commission of a felony, and the final count being possession of firearm by a convicted felon.
Yes, sir.
Mr. Avery, can you slide towards the microphone a little bit? It'll make it easier. You two can swap or just slide down a little bit. I want to make sure, Ms. Rivers, you're low spoken, which is fine. Closer to the microphone will make it work.
Okay.
All right.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Mr. Ed Adams, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Adams, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Avery's name?
We do.
Mr. Avery, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Adams, do you know of any outstanding warrants related to these charges?
I do not.
And Mr. Avery, has your attorney advised you the minimum and maximum sentence for the charge that you're pleading to?
Yes, sir.
And Your Honor, since this is a possession of firearm by a convicted felon, and I do not believe Mr. Avery has any previous violent felony convictions, the minimum is 1 year and the maximum is 10 years for that particular count.
Okay.
Do you understand that this is a negotiated plea of guilty, Mr. Avery, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, and I will elaborate as far as the state's reasoning, the state will move to dismiss counts 1 through 4, the 3 counts of aggravated assault, and the 1 count of possession of firearm during commission of a felony. As to count 5, the state's recommendation is 5 years probation. The special conditions of probation being that Mr. Avery attend an approved anger management course, and that he also attend a approved parenting class. And Your Honor, that he not return to the incident location.
Which you'll tell me about. Okay.
Yes, Your Honor. Was that the negotiated recommendation that was communicated to you, Mr. Avery?
Yeah, that's all right. Yeah.
Yeah. Oh, yeah. Oh, yes, sir.
Okay. Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the courts can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that since you're being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, the ability to obtain employment.
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you'll be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
You understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty.
Yes, sir.
You understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself.
Yes, sir.
You understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
Mr. Avery, how do you plead to the charge of possession of firearm by a convicted felon and indictment number 21 SC 179115?
Guilty.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
You understand that you only have a limited right to appeal this guilty plea conviction.
Yes, sir.
You understand that since this is a felony charge that you're pleading to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
And Mr. Adams, did you advise to Mr. Avery his deadline for filing a direct appeal?
I did.
Thank you. And Your Honor, for a factual basis on this case, on March 28th of 2021, an officer from the APD was dispatched to 1959 Metropolitan Parkway, Southwest in Atlanta, Georgia, zip code 30315, for reports of a pedestrian robbery. At that time, Your Honor, I was able to watch the body cam in this case. Essentially, officers in the nearby vicinity heard a gunshot. When they did report to the scene, they spoke to, I believe it was Mr. Avery's son. Mr. Avery's son had just been robbed at gunpoint by another group of children or juveniles. So the officers were simultaneously investigating the gunshot and also investigating the robbery that happened to Mr. Avery's son. The officers were able to find out that one of the children well, actually, if I can back up, Your Honor, in this particular case, I believe that Mr. Avery was contacted by his children or by his child after they had been robbed. He came down to the scene, according to the juvenile children that were interviewed. He came down asking where his son's phone was that had been taken from him. They said that they had no idea where the phone was. It was alleged that he then fired a single shot out of his window at the children. Officers pulled up pretty much within a few minutes of the incident and did interview Mr. Avery about it. The officers were given consent by Mr. Avery to search his vehicle. I believe it was an expedition. They did find a loaded weapon in the third row under the seats. There was one bullet missing from the chamber. I believe officers said that it was capable of holding at least 7 or 8 shots, and that one chamber was empty. The hammer was cocked, indicating to them that a bullet had been fired. Your Honor, the reason why the state feels comfortable moving forward with dismissing counts 1 through 4, which were specifically enumerated for firing shots at the children, is that the shell casing was never collected from the particular gun. There was allegedly DNA swabs that were taken from the gun that were never tested. The children of the parents of the children were not willing to let their children come and testify in this matter, so they were uncooperative. So the state felt comfortable with just moving forward with only the possession of firearm by a convicted felon. And of course, officers were able to determine that Mr. Avery had previously been convicted of a felony. You may hear from pretrial, Your Honor, that Mr. Avery does have quite a few convictions in his criminal history, but at least from my review, they are all from the span of 2000 to 2008. So Mr. Avery had spent a long time without any serious charges. We believe that this is a fair and negotiated resolution, Your Honor, given the facts of the case, given that the state may have had a hard time with the aggravated assault counts, given that the parents of the children did not want them to come to trial to testify. So we believe that this is a fair negotiated resolution, Your Honor. So we just ask that you accept this.
You've referred to them as kids and juveniles. How old are we talking? Are these 8-year-olds who got shot at, or are they 15-year-olds who got shot at? If they got shot at, but the people who allegedly took Mr. Avery's son's phone.
Your Honor, I believe that the oldest of them was now 16 years old. So this was 2 years ago. So that would make him 14 at the time. So I believe that the ages ranged from 14 to 12.
Okay, so not little kids, but not 17-and-a-half-year-olds either.
Correct.
Somewhere in between. Got it. Do you know if Mr. Avery's son got his phone back?
Your Honor, I do believe that he did. In fact, how the officers found out that one of the children had actually committed the armed robbery was that the child asked one of the officers to take him behind the building to retrieve a hat. The officers went behind the building with him to retrieve that hat. They found the phone, his son's phone, nearby.
Okay.
So, and that child, I believe, may have been adjudicated in juvenile court.
Okay, got it. Ms. Jackson, last plea of the day. Can you share with me the information you've got on Mr. Avery's criminal history?
Yes, Your Honor. The defendant has 26 cycles. The defendant's last arrest was August the 11th, 2019, with the City of Atlanta Police Department for interference with government property and a misdemeanor obstruction of an officer and simple battery family violence. There was no disposition for that arrest. The defendant does have prior felony convictions, one in 2008 out of Gwinnett County for the sale of cocaine. There's one in 2004 for possession of controlled substance, and one in 2002 for possession of controlled substance, and one in 2000 out of Gwinnett County for possession of controlled substance. There was one in 2001 for Terroristic Threats Act. The defendant does have one misdemeanor conviction. It was in 2009 for battery. Nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, it doesn't sound like Mr. Avery would be on probation now because those are all old convictions.
Correct. The last one ended November 8th, 21 in Gwinnett. So.
Okay, great. Thank you. Mr. Adams, what do you want to tell me about the situation?
Yeah, we agree with what the state has said. Mr. Avery is 45. He does have works in home improvement, has 7 children. As you hear from the testimony, has been out of trouble for a good while. We'd ask you to accept the recommendation.
Okay. Mr. Avery, how old was the son who got robbed and had his phone taken?
It was my son, cousin, that phone got taken, but my son at the time, I think like 15.
Oh, so it wasn't your son's phone. He was with a cousin.
Yeah, they was together.
They both got robbed.
They both got robbed, but he the only one they took something from was his cousin.
Okay. They didn't take anything from your son?
No.
Okay. Because he didn't have anything, or?
He had something. He just refused to give it up. And one of them hit him with the gun.
Hit your son with a gun?
Yeah.
Okay. And how did you learn about this?
I got a phone call from the skating ring.
From whom?
They called me from the skating ring. I was at home.
Got it. And they called you from where?
The skating ring.
What's that?
The Metro on Metro.
Oh, the skating rink, you're saying. That's where this was. So this 1959 Metropolitan Parkway is a skate rink.
Yeah,
Oh, got it. And that's where this happened.
yes, sir.
You come over there and you encounter, they say these are the guys who did it, or how did you know? There are lots of kids there. It's a skating rink. How did you know who to be unhappy with?
I mean, I went and got my kids. I mean,
You got your kid, but did they say those are the guys who did it?
I mean, apparently when we was coming down the hill, when I was exiting out the Metro, that's when I was stopped.
Okay.
That's when this story came about, because they were stopped first for the armed robbery.
The kids who robbed your son and your nephew.
Yes.
Okay.
And so then I guess whatever story they told them,
Okay. You were the bad guy.
yeah. So when I come down the hill, that's when they stopped me.
Okay.
And you know,
Did you have your nephew in the car as well?
son, yeah, I had both of them.
Okay.
Son and my nephew.
And he got his phone back?
Yes.
Okay.
Yes.
Got it. But you got arrested because of the story / you had this gun
Yes.
way in the back of your car.
Yeah, but yeah, slash the store. Then I gave consent to search the field.
Okay. Did you know there was a gun in the car when you let him search it?
If I did, I wouldn't let him search.
Okay, that's the part I'm trying to figure out, because I know you knew you shouldn't have a gun. So I don't know what you thought was going to result from that.
Exactly.
Any idea how the gun got in there?
Well, I already told me it was left by someone I dropped off at the house. So apparently, you know, I didn't know it was in.
Okay, was it your car?
It's my vehicle. Yeah.
Okay, so you just got to be thoughtful about who's getting in your car and what they got with them, because you're one of the last people on the planet who needs to be around a gun with the criminal history like that. Just each time they'll hit you with that, oh, you can't have a gun. So you just need to be careful about that. All right. I think this plea makes sense now that I've heard more about it. I find there is a factual basis for the one count of you possessing, it was your car. So what's in the car, you're on the hook for a firearm, but you're a convicted felon several times over. I also find that your plea is knowing and voluntary. You'll feel like anyone's forcing you into this plea, or you're comfortable moving forward.
I'll move forward, sir.
All right. Any questions about anything we talked about?
No, sir.
All right. I'm sentencing you under the Probation Options Management Act. So while you're on probation, if you have any small violation, you and probation work through that. If it's bigger, you get caught with a gun, anything like that, that comes back to me and we'll figure out what the consequences are. Mr. Avery, may my staff sign the indictment indicating your guilty plea?
Yes, sir.
Mr. Adams, can we sign for you?
Yes, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
We'll do that. You've got 7 kids.
7 and 1 on the way.
One on the way. What do you do so that they all have food and clothes? What's your job?
Home improvement, pain.
You do it on your own? Like there's Avery?
I also have a company.
Okay, you work for him or with him?
Yes, sir.
Okay. You get enough hours doing that?
Oh, yes, sir.
All right. How many of the kids live at home with you?
I see.
So only one doesn't live there, but you're about to get number 7 anyway.
Yes.
Okay. Any reason you're having number 7? You like having all those kids around? They seem to be wearing you out.
Be blessing. It's a blessing, I guess. It's a blessing, they say.
Okay. As long as that's how you treat it when they're crying, you need to change the diaper at 3 a.m, it's a blessing because you got plenty.
I've been through it long enough. So
Well, but you know how they don't just fall out of the sky. You're making them. So you may want to say, I'm 45. I don't need 10 kids. You don't get it. The governor is not going to give you a medal for number 10. He's not going to give you extra diapers for number 10. You're going to have to paint even more houses. So, but when you get old, you're going to have 500 people who can take care of you, assuming they want to.
yeah.
All right. Mr. Avery, I'm going to follow the negotiated recommendation, sentence you to 5 years probation. There will be 3 special conditions. Number 1, take an anger management course. Number 2, take a parenting course. And number 3, no more skating rink for you. Just don't go there. If your kids are there, someone else needs to pick them up. But for now, stay away from there.
It's gonna close down anyway. Yeah,
Well, that'll make it easy. But whatever it becomes, if it reopens as some laser tag place, don't go there or whatever. At that particular address, don't go there, especially if it's the kind of place where your kids might go and then they get mixed up with something and you come down there and who knows what happens. I'm going to set for you, just like I did for Mr. Holt, a behavioral incentive date. I'll set that for January 27th, 2024. So 2 years out. If 2 years out, there've been no issues, don't get arrested for anything, then that'll be a time you don't owe any restitution. So if you've taken those 2 classes and everything's been good for 2 years, they'll close the case out, knock 3 years off it. Okay. If, however, you get popped for something between now and then there goes the behavioral incentive date, and you will have bought yourself the remaining 3 years of probation. Okay.
Yes, sir.
All right. Mr. Jordan, anything else in Mr. Avery's case?
Nothing further to say here.
Mr. Adams, anything else?
So, yeah,
Mr. Adams, you need to be here Monday morning for Mr. Way's case.
okay.
Is back up to Norris. It looks like Norris is going out, but strange things can happen. Lawyers can get sick. People can take pleas.
Mhm.
So the number 2 case out on Monday is Mr. Way.
Okay,
You'll be here?
I'll be here.
Good. Is Mr. Way, he's going to need clothes. I mean, if he goes, he's in custody. So you'll need to work with his family, whoever got you in the mix, so that he can get dressed out.
Okay, thank you.
All right?
All right.
Mr. Avery, you're going to need to speak with Ms. Tucson. She'll get you signed up with probation.
I want you out in the hall.
When she's done with you, you're free to go.
All right.
All right?
Thank you.
All right. Thank you.
Thank you. Thank you, Ms. Jackson. Thank you, Ms. Rivers, and Ms. Nelson or Ms. Hansberry, whoever's on. Thanks, all of you. Have a great weekend.
Have a
You
good
as well,
one,
Judge.
guys.
Thank you.
All right.